Hi there, I'm James Dapperchi and this is Coffee and a Case Note. I'll have a sip later. Team, today we're going to talk about exclusion clauses, and to set that up, let's work through some facts. So we've got a coffee producer, we have got a delivery service provider. They enter into an agreement, and the agreement relates to pallets. And in short, our coffee producer will fill up a pallet with coffee. Our delivery service provider will come, collect the pallet, deliver the coffee off wherever it needs to go. And pursuant to the agreement, the following week, the delivery service provider is going to come and return the same number of pallets that they collected the week before. So Monday of week 1, collect 5 pallets from the coffee maker. The following week, return 5 pallets to the coffee maker. Right? 1 week delay, same number of pallets you take are the same number of pallets that are returned. Seems nice and easy so far. Right, there are 2 contracts that apply to this relationship. One contract is long and rigorous and in writing, and it was prepared in essence by the distributor, and it includes a clause in it that purports to exclude liability for certain things relating to the delivery of goods. Thank you very much. That's fantastic. Cheers. For a period of 90 days. That's one contract. The second contract is actually on the back of delivery dockets that drivers and that the coffee manufacturers can fill in, rip off a copy. We took 5 pallets today, so next week we've got to return 5. So 2 contracts, one big, long, rigorous written one. Second is a little rip-off docket receipt. Now, forgive me. The big, long, rigorous contract has a clause that is drafted ambiguously that attempts to exclude liability for 90 days. I'll come back to that. And the second little docket has in bold caps words to the effect of no claims accepted for pallets over 90 days. I think you know pretty safely where we're going. So this arrangement rolls along for about 3 years or so until 1 January, our coffee manufacturer sits down, does its sums on the number of pallets that have gone out and the number of pallets that have come back, and says, oh, hang on, we're behind 1,067 pallets. All these pallets are missing. And makes a complaint to the distributor. You haven't returned all the pallets you're meant to return. And so a dispute arises about what the distributor is required to do. Because I'll now refresh your memory. We've got the big long written contract that purports to exclude liability for that 90-day period, and it does so in ambiguous terms. And then we've got the little docket, bold caps. I'm seeing it, you're seeing it, coffee producer's seeing it, delivery provider is seeing it. It says no claims accepted for pallets over 90 days. So there we are in January. This claim is made. And at first instance in the district court, what the judge finds is that the big long written agreement, 90 days, that holds up. And so the only claim the coffee manufacturer can make is for pallets within that 90-day period. We're now in the Court of Appeal. And what the Court of Appeal says is, no, the clause in the big long written agreement is ambiguous, and because the deliverer drafted it, it is to be construed contra preferentum. Where there's ambiguity, it's to be interpreted against the party that drafted it. So sadly for the delivery service provider, they can't rely on the big long written contract, but the Court of Appeal then turns to the big bold caps on the little dockets that our driver and our coffee manufacturer rip off every time a pallet leaves the coffee factory, where that says no claims accepted for pallets over 90 days, or whatever the formula of words I used before was. And what the court said, well, that has contractual status, that is binding on the parties, and so that second unambiguous contractual clause term applies to the relationship, which means that despite the fact that there's 3 years in which the coffee manufacturer is behind in pallets, the claim is only to be made for 90 days. That's the thrust of our discussion today following the court making that finding, there is discussion of how we do the maths. Do we apply the newly re-delivered pallets to the previous week, or do we apply it back to the start of the 3 years? First in, first out. How are we going to do our sums? That's a further, respectfully, marginally less interesting discussion that we can go into if you'd like. But for the moment, I hope that quick chat about exclusion clauses, contra preferendum and that sort of stuff assisted you. And I hope you have a great day. Cheers.